Hello, and welcome to 4AP Council's webinar, What You Need to Know About Copyright and Music. My name is Claudia Tapia. I'm the chairperson for 4AP Council and will be your host today. Next. As you may know, 4AP Council is a not-for-profit research council developing high-quality academic insight on topics related to intellectual property and innovation. We collaborate broadly with many organizations. Today's webinar was co-marketed with the European Commission's IPR help desk, who I'd like to thank for their support. Next. Our educational work includes resources for encouraging innovative SMEs to grow their businesses using IP. Among the resources, you will find an interactive graphic about using copyright called 4 Reasons for Copyright. Visit our website for a range of free materials. Next. Please allow me to briefly introduce you to our great speaker, Dr. Hayleigh Bosher, who is today presented her second webinar for 4AP Council. Hayleigh is an internationally published legal academic, speaker, and legal consultant, specialized in IP, media, and entertainment law. She is a lecturer at the Brunel University, London, visiting research fellow at the Center for Intellectual Property, Policy and Management, blogger for several IP magazines, and founder of the World IP Women Network. She also holds a PhD in copyright law from Brunel University. The slides and a recording for this webinar will be made available on our website alongside Hayleigh's previous webinar for us on copyright and social media by this Friday. Please, if you have questions for Hayleigh, post them in the Q&A area on your screen. Without further delay, Hayleigh, the floor is yours.
Oh, great. Thank you for unmuting me. Sorry, I couldn't find the button. Thank you so much for your lovely introduction. And I'm really happy to be here today to talk about music and copyright, which is one of my favorite topics to talk about. I really, really enjoy it. And I hope that you enjoy this webinar and that it's useful to you. I'm putting a timer on because I have a tendency to get carried away. But yes, any questions that you think of, please drop them in the Q&A, and we'll have time after I've talked for about half an hour to address your questions. Hopefully we have time to answer them all, but if not, I will answer them afterwards. Okay, so I'm gonna there we go. Sorry, next slide. I'm going to start off before we get into the copyright discussion to first, I kind of feel like if you're already here and you're already listening to this webinar, then maybe you already know why copyright is so important for the music industry and music creativity. But I still feel like it's really important to emphasize these reasons, because there's a lot of misconceptions around copyright, a little bit of misunderstanding on some of the reasons why we have copyright in the first place. And it's my view that understanding a little bit about why copyright even is can help kind of more and better understanding when we get to the real kind of application of copyright to music. So the first thing is that copyright sometimes gets a bad reputation. People think that it's often a barrier to creativity because you have to clear licenses, and sometimes that's challenging. But actually, the reason why we have copyright in the first place is actually for creators and for creativity. It's really there as a legal tool to help encourage creativity and culture for the benefit of society as a whole. And the way that it does that is it grants a right to the creator or the author, and that then allows them to be rewarded for their creativity by enabling them the control over their work. So there's different types of kind of theories and justifications of why we have copyright, and different countries tend to lean towards different ones. In the UK, where I am, we like to take the economic perspective, which means that we say that the copyright holder is encouraged to create because of the remuneration that they receive for their work. In other jurisdictions, like France, for instance, they like to emphasize the personality rights of the creator, which means that they believe copyright is important because when you create something, it's an extension of your personality and it's an extension of yourself, and therefore you should have the right to own it. I think that it doesn't really matter which one you prefer, because they're both, and these aren't the only ones, these are just the two main ones. But either way, whether you prefer or lean towards one or the other, the emphasis is always on the benefit for the creator and society as a whole. So I think if you start from that perspective, even though, of course, there are regulation and policy within copyright that maybe need to be updated and aren't optimizing at all levels for creativity. I'm not saying that copyright is perfect, and certainly not the regulation and all the rules are great, but copyright as a principle and as a concept is really there for creators and for creativity. And I think that's a really important starting point when we come to talk about copyright. And then when it comes to the policy and the regulation and the rules around how copyright operates, well, the way I kind of put this to people is that, copyright is human made. It's not something that it's not nature. We can change it. So if there's a problem with the policy and it's not making creativity optimal, then that's something that we should work on and look at to change. So the actual rules and the policy can change, but the principle and the reason why we have copyright, I think, is important to know that it's really for creativity. For the music industry, copyright we would really say that the music industry is a copyright industry. And what I mean by that is that the way that the music industry primarily makes its money is through copyright. It's through the fact that copyright enables the rights holder to control a song or an album or some work. And that is the way that it's the industry runs, by monetizing based on that kind of right and that restriction. So the music industry contributes hugely to the overall economy all over the world, particularly throughout Europe and the US. And it does that through sales of physical CDs and digital music, through music retail, merchandising, publishing, live music. There's lots of different ways that the industry make money. But what I'm saying when I'm saying it's a copyright industry is the fact that we have copyright enables all of these different ways for the music industry. And by music industry, I mean everybody from the artist to the publisher and everybody in between, to utilize an income from all those different sources. So I do want to just say that when I talk to musicians, especially young aspiring musicians and artists, I found that there's a little bit of reluctance about when you talk about making money. They're like, it's not about the money, it's about the love of music, which is great. And you can see my next point is it's not just about the music, it's not just about the money. I have some points about that, but I think it's important to remember that there is a stigma around, the struggling artist, and that this beautiful poetic kind of notion that the creator is about the creativity and not the money. But I like to try to kind of dissemble this imagery, because I believe that making money is like exchange of energy. For you put in the energy of your creativity and you get rewarded back financially, and that enables you as the creator to continue to create, and that benefits society as a whole. So it's not a selfish or greedy thing to think you should make money from your creativity. So yeah, I just wanted to say making money for your creativity is important, but it's not just about the money. So the other things that copyright give you, that's not just financial, is also the control over what happens with your work and your music. So for example, you might have seen in the news recently that some artists and musicians are suing Donald Trump, and there was also a case in Australia where political parties have used songs in their campaigns, and when they're doing rallies, they play this music that they walk out to on the stage, and the musicians or the artists don't like it because they don't support that particular candidate, and they don't want their music to be used in that context, and they can sue for copyright infringement. And that's copyright gives you that power in terms of, again, it's not just about the money, it's also about the control where you want your art to go. It also allows you to be identified as the creator. When I was working on a project called copyrightuser.org, we interviewed some old creators actually, but we did a certain episode with musicians and music artists. And many of them said that for them, the really important thing about copyright was recognition that they had made that thing, that song, when you hear that music, it was created by that person. And that is just as important to them as anything else. And copyright supports that. So there's other reasons why copyright is important. It's not just the income, although I believe the income is a great part of that. So the other reasons why I think copyright really matters to music and the music industry and creators is that understanding copyright can help with your creativity and also how you run your business. And by business, I mean in like the broadest sense. Even as an artist, you think of yourself as a kind of business, and how you are presenting yourself as an artist. But also, obviously, if you're business in the music industry, you need to know how copyright works. So what I mean by that is understanding copyright can help your creativity, because if you know how copyright works, you know the parameters within which what would be copyright infringement, what would not, what would be taking inspiration and what would not be. And I'm going to get onto those topics in this talk, so hopefully that will become clearer. And also, there are certain practices, which I'll mention some tips as we go along, that I think it's a copyright thing, really. I'm giving these tips from a totally copyright perspective, but actually they will enhance your, keeping a record of your creative process. That kind of thing is actually, from a copyright perspective, a very sensible thing to do. And I think the other thing I wanted to say about this is, with copyright, as I mentioned, it changes, and it should change. It should always adapt to new technologies and new consumption behaviors. And, the rules are not static. And I think it's important as a creator and as someone in the music industry that you get involved in policy, because the policy and the legal rules, as they change, they would have a direct impact on your creativity or on your business. And therefore, it's really important to be part of that conversation. So in order to be part of that conversation, you need to have a basic understanding of exactly what copyright is and how it works. So that's another reason why I think it's important. And lastly, I think it's really important to understand copyright so you can avoid making mistakes. And by mistakes, I mean overstepping the line between taking inspiration where you think you're taking inspiration, but really it's copyright infringement, or not registering your copyright when you need to, for example, if you're in America. As I mentioned already, keeping a record, things like those little copyright nuggets, as I would call them, can really help enhance your general business, but as I say, avoid mistakes that later down the line, I've talked to a lot of clients where it's like, oh, I wish I just knew that if I'd done that at that time, it would have saved me a lot of trouble here and now. So that's why I think the little copyright nuggets can be very helpful. So hopefully you're all convinced that you're in the right place, and I'm going to try to give you some of this copyright understanding that I speak of. So first of all, I'll do some quick copyright basics. I'm not going to do an entire lecture on just what copyright is, because I don't think that would be very fun. But obviously, in order to go any further, we just need to all be on the same page and know what it is that I mean when I say copyright. So I'm just going to give you some basic general pointers about what it is that copyright covers. So first of all, copyright is a type of intellectual property right. And I think there's a lot of confusion out there between the different intellectual property rights. Even I read in the newspaper, journalists write plagiarism when they mean copyright. They say trademark when they mean patent. It's a very common misconception to get all the words mixed up. And I don't think I'm not going to go and explain all the different types of intellectual property, but just to understand that intellectual property is an umbrella term, and underneath that you have lots of different types of IP. And just in general, it's good to think of them as protecting different types of things. So a trademark in general would protect your branding. A patent protects an invention, and a copyright would protect things like a literary, artistic, dramatic, or musical work. So a literary work is basically something written down, like a book or a poem. An artistic work can also be a photograph, but a painting or a drawing. A dramatic work might be a play. And a musical work, obviously a musical composition. And you'll see the word original in front of those categories. So copyright law categorizes different types of creative output, and we call them works, into these different, decompartmentalizes them into these different groups. And if they don't fit in one of these groups, then they probably can't be protected by copyright, but there might be other types of intellectual property rights that apply. Original, literary, artistic, dramatic, and musical work. So original is not defined in the law. We look to the case law to try and understand what it is that original is like. Not necessarily the same meaning in the law as you might mean in everyday terminology. So what the judges say originality means in copyright is using your own skill, labor, or effort. And in the European courts have kind of catchphrased this as own intellectual creation. And what that means is you make your own free creative choices in your work, and you kind of put your own personal stamp on your work. In general, we would say that the threshold for originality in copyright is fairly low, but obviously it has to be not copied. It's got to be something that is original in the sense that you haven't copied it from someone else. We'll go more later on into the difference between copying and taking inspiration. So copyright also protects sound recordings and films. These don't have to be original because it wouldn't work. If you think about sound recording is the fixation of a musical composition, and the musical composition is the original part. So that's the only reason it doesn't go in the list above. And a sound recording in music, you might call it a master. It's just when you set down the record of the musical composition. So I mentioned a minute ago that sometimes you need to remember to register your copyright. It is important to know that copyright actually arises automatically. So you don't actually have to do anything in order to have copyright in your work, as long as it's something that can be protected by copyright. So it fits within the list of things that I've just talked about. And it's original if it's within the top categories. And some countries, like in the UK, you have to have it fixed in permanent form. So you have to have written it down. And if it's a literary work, it would be anyway. So once you've got those, you've reached those criteria, your copyright arises automatically. So I automatically already have copyright in these slides, for example. But in certain countries, like the US, you have to register your copyright in order to pursue it in court. So if you wanted to bring a claim for copyright infringement, you have to register it beforehand. So it's just common practice to go ahead and register from day one there anyway, because it gives you more enhanced rights. But technically, your copyright just all over the world is the same. It arises completely automatically. And that's why one of the things that I mentioned, one of my key tips is to keep a record of your creative process, because if you haven't registered it, then there's no definite date to show when something was made, like you would with a trademark. You go and you register that on a public register so anyone can look it up and see that it's there. So with copyright, it's a good idea to keep not just a record of the finished product. You get this, I don't know, like people say, oh, you just post it to yourself and that's how you get copyright. It's kind of like a myth. It's not wholly incorrect, because I see what they're saying, where if you post it to yourself, then it's got the date stamp from the post office, and that shows that the thing was created at that point. So what you can do instead of that, which might be a bit easier, is to just email it to yourself or use any software that has a digital date stamp. There are also there are online registers that you can register with if you want to, but you don't have to. And as I said, it's not evidence that you created that thing, because all it does is show that the work was created on that date of registration. What's much more compelling in terms of whether you created something is to keep a record of the creative process, the whole creative process, because that way you can show where your inspiration came from, when you did it, how you did it, and that's much more convincing that you were the person that created that. Okay, so once you have copyright in your work, that gives you the exclusive right to copy, license, lend, perform, communicate your work to the public. And that's actually not a definitive list. There are some more things, but essentially it gives you the control of your copyright work within. There are some limitations, which I'll just mention in a minute. But this is what I was saying before, where you can license it, you can assign it, and that's how you would make income from your copyright, or you could just sell the work yourself or self-publish. And then communication to the public is, for example, if your song is played on the radio or in a pub, they will pay a license fee to the collecting society, and then you get a cut of that. So that's the kind of chain of remuneration that you can get from your copyright work. And like I mentioned, it's also about control. So no one can copy the work without your permission or use it, like I said, in the campaign. Or there's other cases where, I don't know if you know the band Muse, they had a lawsuit with a coffee brand because they used the version of it was a cover, they'd covered a song, Feeling Good, and I want to say it was Nescafe used it in their advert, and Muse weren't very happy about this. So same kind of thing. It was more because they had ethical reasons why they didn't want their song mute. But really the way to enforce that was that they had the copyright in the song and it hadn't been licensed. So that's just another example. And lastly, it's a territorial right. So I've mentioned already, blah, 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 in the UK, or for example, in France, or for example, in America. So just to specify, the rights are territorial, meaning they're different in different countries, and therefore you need to be aware of the rules of the country that you're in or operating in. I've just seen that it's already 20 minutes gone by, so I should probably get crack on. So copyright limitations, I'm not going to go into these. I just really wanted to make sure that you were aware, because in the previous slide, I'm talking about everything that copyright gives you, and I just want to be clear that it's not a monopoly right. You don't have complete and utter control of every type of use. It doesn't last forever, and it doesn't cover everything. So one of the things that it doesn't do is that it does not protect ideas, only the individual expression of an idea. I'll go on to how long it lasts in a minute when I talk about how it covers a song. There are copyright exceptions. These are circumstances where they don't need to ask your permission to use your work because it falls within a specific copyright exception. Each copyright exception has criteria that needs to be fulfilled. Some of the main ones that would be relevant in music might be criticism and review. So if someone is reviewing your album that are on YouTube, they can play snippets of the song. And that would be probably, depending on the circumstances, I don't want to say that it always would be. might be fall under the copyright exception for criticism and review. Same with parody. If someone makes a parody of your music video, for example. These are the EU copyright exceptions. In America, they have fair use, which is, say, the equivalent, because I mean, it's also circumstances where you wouldn't need permission, but the rules are slightly different there. Another way that copyright is limited is this thing called exhaustion of rights, which is where once you have sold the CD, then the consumer can resell the CD, for example, on eBay or at a car boot sale. Your rights are, we would say, exhausted at that point, but it only applies for physical goods and not digital. Okay, so copyright in a song. As I've mentioned, there's all these different categories of copyright. And you can see here we've got 7 points that might apply just to one song or sound recording. So the melody or music composition, that's covered as a music work. And that is usually, well, it would be initially owned by the creator of that musical work. And then if you just made a song and that's all you did with it, then that would just be yours. But usually if you are working in the music industry and want to publish with a record label or a publishing deal, that kind of thing, you would license or assign your copyright in your musical work to your record label. The lyrics of the song would be covered as a literary work, obviously, again, initially owned by whoever wrote the lyrics, and then usually licensed or assigned depending on the circumstances. The master, which is the recording of the musical work, and likewise the recording of the lyrics, is called a sound recording, and that would usually be owned by the producer. So producer in copyright doesn't necessarily mean producer like music producer, although it sometimes can be. It means the person or the company that made the arrangements for the sound recording to be made. So if it was the record label, like you get a record deal and the record label like fund and set up and organize for you to go into the studio and record a song, and they would be the producer in that situation. The album artwork would be an artistic work, so that would be initially owned technically by the creator of that artwork, but again, if it was done under contract, it would be licensed or assigned, usually assigned. Sorry, just to specify, a license would be when you grant your copyright to somebody else, usually for a fixed period of time or for a specific purpose, whereas, but you still own it, but you're just like licensing it to them as in they can use it for the purposes specified in the license. An assignment is more like you give it to them. So it's like you're not the owner of the copyright anymore. And whether you license or assign would depend on the contract, the record label deal or the publishing deal, and depending on the norm for that particular type of deal. So, sorry, I just thought I wanted to explain that before in case I was confusing anyone. So our album artwork will be artistic work. You also have performers' rights in the performance of the song. If you have a music video, that would be protected as a film. And there will also be moral rights involved. Moral rights are like kind of, we say, sister rights or partner rights to copyright. And that gives you right to be identified as the author and not to have your work modified without your permission. So you could enforce your moral rights if somebody, for example, used your music in a film without your permission. You would also use your copyright. So just to give you an idea of the extent of the protection. So each of those different types of copyright that apply just to one song, they all have their own different length of copyright as well, just to make things really simple. It actually looks more complicated than I think it is, because some of them are the same. So the musical composition or the melody lasts for as long as, and this is normally copyright in general, we say, lasts 70 years after the death of the creator. And that's the same for the musical work and the lyric, because those are the artistic and literary works. The master's is 70 years after publication, or 50 years after it was made if it was never published. Performers' rights is the same as the sound recording one. So, and then the album artwork, because that's an artistic work, would be 70 years after the death of the creator, same as The music video. So films are very complicated, and they're usually owned by the producer and the director together, although everything is subject to contract, so it could be different. And in order to decide how long the copyright lasts, both of if it was the producer and the director who are the copyright holders, it's 70 years after the last one of those people die to work out. So that could be quite complicated to figure out who is the copyright holder and then how long the copyright lasts for that particular product. And lastly, moral rights. So in the UK, the moral rights last for as long as the life of the copyright, but in some countries like France and Spain, they actually last forever. And within the moral rights, there's 3 different types of rights. And actually in the UK, they don't even all last for the life of the copyright. One of them is life of the copyright holder plus 20 years. So it's a little bit complicated. And to be honest, I think the main thing is just to remember that if you're clearing rights, then you have a lot of things to check in terms of the different lengths of time, but it's all pretty much a very long time. So in the remaining time, I just want to talk about copyright infringement. I think one of the most common questions I get from musicians and artists, and actually copyright creators in general, is what is the difference between copyright infringement and taking inspiration? And I'm really sorry to tell you, there is no clear answer. It's really not that simple. I can't just say to you, oh, this is copyright infringement, this is not. But what I will try to do is explain to you a little bit about what is infringement, and then you have an idea of what we're talking about. But it's not it's not that clear cut, I'm afraid, which kind of makes it more fun, to be honest. So it is absolutely not copyright infringement to take inspiration at one end of the spectrum, if you like. And then at the other end, it is obviously copyright infringement to take the whole of somebody's song and just play it or use it without permission. And then sort of everything else is in between. The law says that copyright infringement is taking the whole or a substantial part of a copyright work. I've put without the benefit of an exception, because remember the limitations that I just mentioned. So not when we're talking about those circumstances. A substantial, so the whole is kind of, that's clear, right? So if you take the whole of someone else's copyright work and use it without permission, that's infringement. Taking a substantial part, that's where things get interesting, because that's where it is all a bit more grey in terms of what that means. The courts say when they are deciding in a case if it's infringement or if it's not, the substantial part relates back to the originality parts. Remember I said that copyright, for it to subsist in the literary, artistic and musical work, they have to be original, which is about the personal stamp, making the free choices. Those are the things that make it original. So if you take the things that are the personal stamps, then that's likely to be substantial part. If you take the things that are more like ideas, like a song about celebrating birthdays or a romantic song, that's an idea, and anybody can make those songs. So they were very inventive examples, were they? But you get the idea. So substantial is about quality, not quantity. It's a very common misconception that if I take a certain number of lyrics or moments from a song, that it would be not copyright infringement. Sadly, that is not true, even with a small sample, which, yes, that was good, seamless sampling. It can still be copyright infringement. Now, some people argue that sampling should fall within some of the copyright exceptions that we mentioned. However, currently the law does not agree. So in the EU, we just had earlier this year a case that went on for 21 years that was about a 2-second sample. And the court confirmed that the copyright exceptions do not apply. It's not a quotation, and you would need a license if you want to sample. Likewise, in America, the law is very clear that if you are sampling, you would need to license. So it doesn't matter how long the sample is. Like the EU example is 2 seconds long, but if it's recognizable in the sense that it's the original it's an original aspect of the song that is about the the own intellectual creation that went into the song, then it would be copyright infringement. So, as I mentioned, it is not copyright infringement to take inspiration. And obviously, especially in music, when we learn to play an instrument, we play other people's songs, everybody learns the same chord structures, and there's a finite number of notes and melodies that can be used. So it's important not to feel restricted by copyright infringement in that sense. And when I say idea versus expression of idea, under the heading of idea, we also get the things like the theme, or like the blues chords would be considered just an idea because it's commonplace. It's not, and if you embellished on that and put your own expression of that idea, do you see the difference? Then it would be copyright protected, and that would be the part that someone would need your permission to borrow from. So I'm just going to give you a couple of examples to try and help you see what I mean by taking up a substantial part. So we had the very famous Blurred Lines case. I'm sure you heard all about this, where the damages were the largest in copyright music history, 7.3 million, but actually it was reduced on the appeal to 5.3. I'm going to try to, I don't know if this is going to work. So, and I also can't see or hear anybody else, so I'm just going to play it and hope you can hear it. Everybody get up. If you can't hear it, you will get the slides, so you can have a listen after. Sounding very similar indeed. But the main problem was that in the evidence, they did admit to specifically trying to recreate the sound. But this was the reason why this is such a big deal, this case, is because we would say it kind of opened the floodgates. We've got lots more copyright infringement cases that came after this one. And some people even now find it controversial that because the parts taken, as you heard, are not actually the main parts of the song. It's even mostly just the in the introduction, the background sound. Nevertheless, the court said that in the Marvin Gaye version, the parts, it was unusual at the time to do that, and so in the new Blurred Lines song, to take the parts that were unusual are to take the copyright protected parts. Oh, sorry. Now it won't stop playing. Okay, here we go. So Dark Horse and Joyful Noise. So Dark Horse is the Katy Perry song, and this fell in line with the Blurred Lines case. There was infringement was found, and this was really controversial because it was really just 8 notes that were the crux of the issue, where they said that it was copied. Let me just play the. That's it. That's the bit. You'll hear it in the other song. Oh, that was not working. But that's all it. Those 8 notes. That's what the crux of the copyright infringement case was about. And in the first instance, it was found that Katy Perry had copied. And it was enough to say it was copyright infringement. But then we had, I was going to keep doing that, the Stairway to Heaven case. So this is actually an older case that was reopened later on. I'm really sorry, that's my dog. Working from home life. So in the 2020 Stairway to Heaven reassessment of the case, it was found not to be infringement in the first place, and then it was actually also found not to be infringement in the second place anyway. But what it did was it provided the courts an opportunity to reevaluate how they were assessing copyright infringement cases, and they specifically said that descending chromatic scales or short sequences were common musical elements that could not be copied because it's not infringement to take an idea, only the expression of idea. And so what was great about that is that then the Katy Perry case that I just said about with the 8 notes, they appealed off the back of the Zeppelin case, and the court case was overturned, which there's a collective sigh of relief, hopefully, from creators, because you should be like less worried now Katy Perry argued that she never heard the original song. But the court decided that on the evidence, it was likely that she had heard it. But the parts that were taken were so commonplace that actually it wasn't held to be copyright infringement. So I am going crazily over time here, and I think I've come to the end. And hopefully we've got time for some questions. I just wanted to, there's a couple of articles and blog posts that I've written more on some of the topics that I've touched on today. And there's also a playlist I made of all the songs that have been in copyright disputes, which you can click on those links if you want to have a listen. I need to stop on my screen and come back over.
Yeah, you did an amazing job as always. Thank you so much for making all these not so easy topics in a very easy way to understand for everyone. We've got already quite some questions, so I'm gonna start first with the first one we received, which is there a number of notes that can be taken from another song without infringement?
Okay, great. So as I mentioned, that's a really common misconception. Lots of people think that is true. And obviously, even now with the Katy Perry case, where there was an 8-note sequence taken and they said it's not infringement, people might even feel more comfortable to say, for example, 8 notes is fine. But that's actually not a very safe way to assess the situation, because it depends on what the 8 notes are. The reason the Katy Perry case was overturned is because the 8 notes taken were commonplace elements. So again, as I mentioned with the blues chords and things like a normal scale it would be commonplace, it would be an idea. But if you took 8 notes that were original combination of 8 notes, then it would be a substantial part and it might be infringement. Does that make sense?
Definitely, it makes. Another question is, if you buy music protected by copyright, and you may have it in a CD and then later on an MP3, how many times do you have to pay a person who buys this music to keep it? Shouldn't be a discount, because when time passes, you lose your music with copyright and you have to buy it again.
Oh, I think I see what you mean, as in like you buy it on a CD and then I don't have a CD player anymore, so then I have to buy it again on iTunes or Spotify or whatever you're using. That's a really interesting point. So in some countries there are private use exceptions where you can take the CD and burn it into a MP3 file so that you can have a digital version. In the UK, we do not have that, so it would be technically illegal to do that. Even within your own home for your own personal use. So technically, the law in the UK is very helpful there. But in some countries in Europe, you do have the private copying exception, which allows you to do that. You also have, as I mentioned, the exhaustion principle. So but that only applies to physical goods. So once you have the CD in your hand, the copyright holder doesn't own the CD. They still own the song, but you own the CD. So you can sell the CD or do what you want with it, lend it to your friend. But unfortunately, because of the way that we consume digital music, we actually only license it from iTunes or wherever you source your music. So you can't lend it because you don't have the right to do that, and the exhaustion principle doesn't apply.
Makes sense. I hear you have a book coming out on the topics discussed today. When will it be released? Where can we purchase it? What is the title? What can you share about it?
Thank you. Yes, I do. So the book is called Copyright in the Music Industry: Exploiting and Protecting Your Rights, and I cover all the kind of things that we've talked about today, enforcement of copyright, management of copyright, and even a couple of chapters on the future of the industry. I looked into some like AI and everything as well. The book is currently in press, so I am hoping it will be out before Christmas. I've published it with Edward Elgar, but it will be available in all good bookstores and on Amazon and all the usual places.
Great. We will pay close attention to that. Looking forward to it.
Thank you.
I have here another question.
Sure.
It says, I wonder about limitation and possibilities regarding machine creation. We are developing AI-based music generator called Zeppelin. I'm sorry. Can your AI machine or can our AI machine get copyright protection over its work?
That's a great question. And as I mentioned, I did some chapters on this in the book. So it depends on where you are and what country you're in, depends on what the law says about this. Currently in the UK, our law says that computer generated work is owned by the person who made the necessary arrangements for the computer to produce that work. So it would be you. But there are issues with, for example, the input data. If you put other people's music into the AI and then it used that music to produce a song, it could be copyright infringement. And the new song could sound substantially similar to a previous song. So you would have to think about the copyright status of the data that you're using as well. Currently, the law is so kind of behind on this that all of the government, well, the ones that I know, the UK government is doing consultation on this currently. So is WIPO, the World Intellectual Property Organization. They are looking at how to adapt the law to these kind of circumstances. But it's actually, I say slow, but it's good that it's slow because it's actually sometimes too dangerous to regulate too early when we don't know what the impact of the new technology is. But currently in your position, if you're in the UK, the owner of the copyright produced would be the person who set up the software. And there has been, this is not the only example, there are songs that are even on like iTunes or Apple Music. I don't know why I keep calling it iTunes, it's actually the old one. That are credited to, it says the author is an AI system, but this is a little bit like a publicity stunt because if you actually go to the copyright register, it's human people that are registered as the copyright owners and the creators of the song, not the actual AI itself.
Great. Next question. To clear rights to use a song, who do you contact?
Okay, so it depends what you want to use the song for. For example, if you own a pub or a restaurant and you want to play music for your guests, then you pay a collecting society who will distribute the payment to the artist. So for example, in the UK, it would be PRS for music. If you wanted to use a song sample in the creation of your own song, you would need to ask the copyright holder, which would usually be if you want to use the sample of the melody, and which you recreate yourself, you would ask the record label. If you wanted to use a sample of the sound recording, you would contact the publisher. Often you actually get middle people who negotiate these for you. So it might be a lawyer, or even there are certain sampling agencies that will help with this kind of thing. So it depends on what it is that you want it for.
Excellent. All questions keep coming. So the next one, it's about moral rights. If you assign your work, are your moral rights still staying with the creator, or is it to be agreed?
This is a very good question. I'm glad that you asked that because I didn't get to mention it. So, with your copyright, you can assign or license your work. With your moral rights, you cannot do that. But what you can do, and often you are asked to do, is waiver them, which is like surrender, you give them up. So you don't license or assign your moral rights, but you can waiver them. If you don't waiver them, then you're correct, they stay with the creator.
Wonderful. Next question. After the protection time passes, what happens with that copyright?
Great. So once copyright expires, we say that the work is in the public domain, and that means that it's freely available for everybody to use. That's why I was mentioning about the different lengths of time on the different parts of the song. For example, you often see when the sound recording is about the copyright in the sound recording is about to expire, then there's like suddenly a 50-year anniversary re-recording of an album so that they can like renew the copyright on that. But yeah, in general, it goes into the public domain. It means it's freely available for everybody to use, but just be cautious. Make sure that you are checking the right amount of time and that it definitely is in the public domain before you use it.
Good advice. Are cover versions protected by copyright law?
Are cover versions? Okay, yeah. So if you make a cover version of a song, that is called a derivative work, and it has its own brand new copyright, and that belongs to you. But you would obviously need permission to make the cover version in the first place. Otherwise, it would also be copyright infringement.
Right. So sampling seems to be a massive part of modern music creation, with lyrics and audio samples. Is it only very high profile and songs that have made large profits that get in trouble? If a song doesn't generate much money, will it go to court?
That's a good question, and I absolutely love the topic of sampling. I wrote a whole chapter on it in my book, and I love it because you're so right, it's a massive part of music these days, and it can get very complex, the layers of the sampling licenses that you need to get approval, and they're always being negotiated at different rates, and sometimes they want to hear the song after you've made it and then decide how much the sample cost will be, depending on how much of the song you've used. In terms of I think you're asking me a risk question, aren't you? Whether it's only famous songs that would get caught. I would say no, because of the way that it depends what you do with it. If you make a sample song and only play it within the four walls of your home, then the risk is probably very low. But if you put it on the internet, the risk is increased because there is software that runs, for example, YouTube Content ID that would identify immediately the sample in the song. It's the same with if you put it on social media. It wouldn't necessarily result in a court case. It depends on the situation. They might just take down your video, for example. But if you were selling the song, like on Apple Music, then you might find a cease and desist, like you have to take it down, that kind of thing. I think just that there is a lot more music production these days, but likewise, there's a lot of technology that will help the copyright owners to keep an eye on who is using their work.
Thanks. So how does copyright work with DJs reposting their sets online?
Sorry, can you say that again? Oh, DJs reposting their sets
yes.
online. Yeah, because I can see the chat. Yeah. Well, it's the same. I don't know if you. I think it's a lot to do with risk assessment, and also if you're a smart DJ, they can figure out the way that they might change the song more frequently in their set. But actually, it depends on where they're streaming it. So Facebook, for example, have a specific license agreement that goes on in the background that the users don't even really know about, where Facebook actually pay PRS, which distributes the money for the use of the song on their platform. And same if they posted it on YouTube, then they might get an advert put in the front, and the money from the advertising goes to the copyright holder. So it does depend on where they are posting it. But yeah, it's a risk really on how because they probably haven't got all of the. If you were playing a DJ set in a venue, then the venue pays the license fee to PRS or to the collecting society. But online, there is no like online. It depends where online you pay for the. You can actually go to PRS and pay an online license, but it depends on if you are doing it on Facebook. You wouldn't need to do that because there's already a license in place.
Great. Sharing of lyrics, word form in social media, is it copyright infringement?
Oh, that's a good question. Do you mean like if someone posts an image and then they like to put the quote of the song? I think if it's, you might find that a copyright exception like quotation applies if it's just a small quote. It depends on it would depend on the context. It could be copyright infringement to copy and paste an entire lyric, like for example, people who make lyric videos of songs that they don't own the copyright to, that would probably be infringement, whereas again depending on what country you're in, but if you were to quote a lyric, then it would probably fall under the copyright exception for quotation.
Okay, maybe the last question for today. You mentioned the issue with politicians using songs on their campaign. If the politician has a license or authorization from the CMO, how can the copyright owner prevent the use?
Well, that's a good question. So they can try, but it's much harder because they obviously have the authority to. They have the copyright permission. If they do not pay the license, then you would sue them for copyright infringement, and that's what I meant when I was saying the example of Donald Trump, where the artist is making a claim for copyright infringement. But there have been other cases where a license was paid, and so they tried to sue under moral rights. And there was another example recently with 50 Cent, where his song In the Club it's actually In the Club, had been licensed, but he didn't want Rick Ross to use the song. And he tried to use personality rights and publicity rights. So these are kind of like associated rights with copyright that people try to use in these situations, but it's much more difficult, would depend entirely on the circumstances. And for example, in the 50 Cent case, he was unsuccessful. So in the example I was talking about, it was a copyright claim.
Hayleigh, this has been enormous, very, very interesting. And, the more questions we raise, the more we receive. We still have a long list of questions for you.
Great. Well, I'm glad there are questions. I will answer them in a blog post like I did last time.
Okay, so maybe we can redirect and help with the questions so that people know where to look at them when we upload also this webinar. And as explained before, this presentation and the recording will be available on 4AP Council website on Friday. And later today, you will receive an email inviting you to complete 1 minute a survey about this webinar, and we will be very grateful for your feedback. Also for everyone, our next webinar is with the Licensing Executive Society International on the 27th of September, and it's about managing your intellectual property. So you may register for it directly on our website. Hayleigh, this has been extremely interesting, and I see from other participants that that's got a lot of attention, and thanks a lot for your time and also for responding the questions that we haven't managed to answer today.
Thanks very much for having me.
Thanks everyone. Bye-bye.
Bye.